The debate on whether or not to open the box containing the tax and bank records of Vice President Sara Duterte is far from over. Good morning. I'm Attorney Karen Jimeno, and this is At the Forefront. Senator judges will decide on Monday if they will subpoena the tax and bank records of Vice President Sara Duterte, as requested by House prosecutors. Some say Article 2, which is the alleged unexplained wealth of the Vice President and her alleged failure to disclose her assets, is the strongest case against her. Will these records be opened during the impeachment trial? To answer this question and more, we'll be speaking to former Senate President Franklin Drilon. Good morning, SP Frank.
Hi, good morning, Karen. Thank you for your invitation to be here again.
Yes, because not only are you a former Senate President, you're also a former Senator Judge in impeachment. I don't know, how many impeachment trials did you sit in?
2 impeachment trials, and there were 2 other impeachments where the respondent resigned, so we didn't have a chance to litigate on it. But let's say I have a master's degree.
Yes, it seems like it.
Yes,
Master's degree in impeachment. So let's start with what happened on Wednesday. The impeachment court heard oral arguments on whether to subpoena the bank and tax records and AMLC records of Vice President Sara Duterte and her husband, Mans Carpio. What do you think should be the important factors to consider for the Senate as to whether to grant this request?
Well, you know, Karen, Attorney Karen, we do not need all this hullabaloo about all these legal arguments. What we must not forget is that Article 11, Section 2 of the Constitution says that the Senate shall have the sole power to try and decide all cases of impeachment. Sole power to try and decide. This is a constitutional grant of power, and therefore all these arguments, all the other statutes cited should yield to this constitutional power of the Senate to try and decide. The other branches of government should not interfere. The Supreme Court should not interfere. The President should not interfere, because the Senate, as an impeachment court, shall have the sole power to try and decide. So all of these issues, all these questions can be resolved if we just stick to what the Constitution says. And what does that mean? Matters as to whether or not a particular, the opening, for example, of the BIR box, that's within the prerogative of the impeachment court to decide. And by the way, there is, of course, there is that provision in the Revenue Code which allows the publication of the revenue returns upon authority of the President. You know, to avoid all of this conflict and conflict of interpretation. The purpose of an impeachment trial is to make our officers accountable for their deeds. And therefore, with this premise, the President should already open and exercise his authority to make available all of these tax records.
Okay, so can you help us break this down? First, you're saying that all these arguments are not even necessary because the impeachment court would have absolute power.
That's correct.
But the wording is to try and decide cases of impeachment, but it doesn't really say that all the other laws are suspended, or is that what you're saying? Because the National Internal Revenue Code, the tax code, is very clear in Section 270 about the confidentiality of tax records, and it even penalizes BIR officials if they reveal or show the details in tax records. But the only exception, at least one of them, is Section 71 of the tax code, which requires the President, by order, to allow the inspection of these tax records, and as you said, publication. So you're saying those are not applicable, or are you saying that...
What I'm saying is that the power of the Senate as an impeachment court is superior to all the other powers granted by a statute. Because we are talking here about a constitutional power to try and decide. But having said that, you know, just to avoid all of this hullabaloo, I would urge the president, for the sake of exposing the truth, to exercise his power to give
To order.
the opening of his VIR box. That's the only way. Otherwise, we will go back and forth, and it will end up in the Supreme Court, etc. So, for the sake of an expeditious disposition of this impeachment trial, the president should already authorize the release of this, the contents of the BIR box.
Okay.
Remember,
so that wala nang
remember-
problema in terms of complying with the law. No questions.
Tama po yan.
But
Now,
SP
wait,
Frank, do you
just-
think... sige, go ahead.
Just one point. The second envelope is too recent to be forgotten. The people went out to the street in 2000.
You're talking about former President Era Estrada.
President Era. If you recall, the question was the opening of a second envelope, which was bruited to contain bank records. And the majority of my colleagues then, we lost by a vote of 11 to 10, said it cannot be opened. And what happened? Well, the rest is history. People got angry because the people in an impeachment trial, especially now, would want to know what is the truth. And therefore, just first from a legal standpoint, it is my view that the president should be authorized, should now exercise his authority to make to authorize a publication.
Yeah. But you know, SP Frank, do you think that the president, from a political standpoint, so this is not a legal question, but since the start of the impeachment that was filed against Vice President Sara last year, the first one, he was distancing himself from the impeachment and saying that he does not want an impeachment against the vice president. Do you think that he would have qualms over issuing this order because malalapit siya dun sa, or yung kahit paano ma-identify siya na he's supporting the impeachment, you know, some of the political considerations?
Well, that is the price of leadership. There are certain issues which you must put your leadership on the line for the sake of the people, for the sake of stability in our system. And in my submission, it is my submission that the president should exercise that authority to open the BIR box. Otherwise, this debate will stay with us, and doubts will be thrown on the authority of the impeachment court to open the boxes. Just for the sake of expediency, because there is no one disputing the right of the president to authorize the opening of this BIR box.
Yes, because it is very clear in the National Internal Revenue Code, no?
That's
that he
correct.
has that power. But the defense also argues that many of the financial records that the prosecution is asking to be subpoenaed are not part of the period within the vice president, was vice president, so that they're saying that this is not relevant
This is
to
not
the impeachment.
relevant. This is not relevant because the previous impeachment court where I sat authorized the examination of accounts even prior to the assumption of office of the impeached official, because it goes into the fitness of the official to hold office, and therefore, and it was an express ruling at that time. And even those in the opposition now, particularly Senator Alan Peter Cayetano, agreed with this ruling. So there is a precedent, and here we work on precedents, and the precedent was that even is that documents or evidence of bank accounts prior to the assumption of office can be part of the impeachment trial and part of the examination of the documents.
So that was how you handled during the time of Chief Justice Corona during his impeachment. The impeachment court authorized opening the bank records, but when it came to the tax records, did you get the authorization of then President Benigno Aquino III?
I do not recall that we had that authority from the president.
But you were able to open the tax records of Chief Justice Corona back then, did you?
We were able to open the SALN, and one of the issues raised was precisely what you're saying now, that these are transactions that occurred prior to the assumption of office. More specifically, the bank transactions, the bank deposits, were made before the Chief Justice joined public office, and therefore the issue was, is this a proper area for examination, is this a proper area for examination of the basis of the impeachment, because it happened before the incumbency of the impeached official. The court then ruled that yes, the sources of the can be opened insofar as the bank accounts are concerned.
SP Frank, we all know that an impeachment is sui generis. So this is not entirely a legal exercise, but everyone says it's also a political exercise. So would it also bind the impeachment court now, meaning the rulings that you're saying that they allowed the opening of bank records in the past, and they also considered bank records that did not pertain to the period of the impeachable officer's term? Would that bind the impeachment court now? Meron ba tayong parang doctrine na sinusunod in the same way that we follow sa Supreme Court? But before you answer this question, we'll have to take a short break. At the forefront, we'll be right back. Welcome back at the forefront. We continue our conversation with former Senate President and former Senator Judge Franklin Drilon. SP Frank, when it comes to legal cases, right, we have stare decisis, we have the decisions of the Supreme Court that become binding for cases that are similar, that would require the court to decide in the same way. But when it comes to an impeachment court, this is sui generis, it's not just a legal but also a political exercise. When you're saying that in the past, during the impeachment of Chief Justice Corona, pinayagan buksan yung tax records, bank records, bank and financial records that even pertain to the term before Chief Justice became an impeachable official. Would that bind the impeachment court now? And you also mentioned some senator judges deciding a certain way, like Senator Alan Peter Cayetano. Would that bind him to decide in the same way as well?
These are precedents, Karen. And under the rules of the impeachment court, the legislative proceedings are suppletory in character, meaning if there is no rule that you find in the rules of impeachment of the impeachment court, then you rely on the rules in the Senate that has been established. And one of those established is precisely in the previous impeachment trial, this was allowed, and therefore there is a strong, persuasive, let's say persuasive material that should guide our judges in making a decision on this point.
But there's nothing that compels them to decide a certain way. Not like
there
sa Supreme
no...
Court may case doctrine na pag
Yes.
diba? So they would have to follow that. But in this case, walang predictability.
That's correct. There is nothing that binds them. In the same manner that there is nothing that binds the gods of Padre Faura, they can decide whichever way they want. As in fact, as they say, our Constitution is what it is according to the wishes of the gods of Padre Faura.
Which are the Supreme Court justices. Sometimes
Court.
they do, they reverse mga doctrines, prior decisions.
These are persuasive but not binding.
Okay, that's why we're held in suspense. We don't know how they will decide on Monday. But Defense Counsel and spokesperson, Attorney Michael Powa, also raised the argument that the prosecution is engaged in a fishing expedition. Do you think that the prosecution has laid out a sufficient basis to subpoena these tax and bank records instead of just asking the Senate to produce evidence for them, to produce incriminating evidence against the Vice President?
Karen, let us not forget that, as you said, impeachment is sui generis, meaning it is a thing by itself. It has no comparison. But remember that the purpose of the impeachment is to find out the truth and make our officials responsible and accountable for their actions. The strength of our democracy is not in the infallibility of our officials, but in the strength of the institutions which require accountability. And the impeachment court is in that genre, is that coin. It is there in order to hold our officials accountable. And the impeachment court is not bound by technical rules of evidence. So you can say these are the fishing expeditions, assuming so. But if that is needed to find the truth, I think there is enough basis to say that yes, it should be allowed.
Okay, so you're saying that kahit fishing expedition man ang ginagawa ng prosecution?
Kung yun ang kailangan para lumabas ang katotohanan, huwag po tayong, magtakot na baka sabihin ng tao nag-fishing expedition. As we repeat, the impeachment court is not bound by technical rules of evidence. Of course, we must observe due process. We must observe constitutional limits. But otherwise, it should have more leeway. Which brings me to the point, Karen. In the last 2 weeks, we have seen that the prosecution and the defense devoted days trying to establish the authenticity
of the video. Yeah.
My goodness gracious. That authenticity has long been established when the same
video was used by the respondent as well.
Yes, in fact, it was cited and used by the respondent.
Yeah.
And was seen by millions of Filipinos. Yes, in a criminal proceeding, you go through that very tedious process of identifying the video, the chain of possession, so that hindi mo palitan. Pero dito naman, dapat ako, and I hope that our colleagues will not mind this in the Senate, we should call them and call the parties, the prosecution or defense, have a stipulation of facts.
That's what I said also. Dapat nga sa pre-trial pa lang, stipulation of facts na on that matter, right? Like, ano ba talaga yung sinabi according to the prosecution? And does the defense admit na sinabi yun? And then tapos na, no?
O kung hindi nila i-admit, then you say, we have taken judicial notice of this, of the authenticity and
or it's a public matter because it came out in the news, in the newspaper.
So that reduces the 2 days of very intense 10-hour question and answer
but
to
your
maybe
point,
5 minutes.
SP Frank, NBI Director Melvin Matibag is supposed to be called as a witness next week. And he is going to testify still on Article 4 of the Articles of Impeachment, itong grave threats. What do you expect Director Melvin to testify about?
I do not know.
You also don't know. You don't know what to expect. Okay.
What to expect? I do not know. Well, maybe to assert that there was a grave threat, but the grave threat is a matter of conclusion of what the facts are. As they say, if you are weak on the facts, pound on the law. If you are weak on the law, pound on the facts. If you are weak both to the facts and the law, pound on the table.
But in this case, ano po para sa inyo ang malakas?
I do not know.
That should already be submitted to the impeachment court for their decision, right? As to whether the grave threats amount to an impeachable offense, betrayal of public trust, other high crimes,
or whether
culpable
the
violation of the
utterances
Constitution.
constitute grave threat.
Yeah.
But those are already conclusions of fact. You don't need an extensive testimony on that. The testimony will just introduce in evidence the tape. The conclusions out of the statements in the tape are matters which will be considered by the impeachment court, whether or not indeed it is grave threat. Number two, whether or not it is a ground for impeachment. or for conviction of the Vice President.
And SP Frank, kasama po sa mga tax records and financial records na pinapasabi na relate to Mans Carpio, the husband of Vice President Sara, who is not an impeachable officer. Do you think dapat kasama pa yon?
I don't know. I don't express an opinion on that. But the income tax return is a joint income tax return. So unavoidably, you will have Mads Carpio's income as reported as part of the examination, because there is no, to my knowledge, there is no separate income tax return for Mads Carpio.
And last question po, sa Constitution natin, the Bill of Rights, our right to due process is high up there.
Yes.
So, I don't think that this is suspended even an impeachment trial, and you can see that as well, right?
No, it is not
Oo.
suspended.
So, kung ma-grant itong subpoena for tax records and bank records on the ground that this is a fishing expedition, and that doctrine on fishing expedition seeks to protect due process rights of respondents or accused, would you think that the respondent here would have grounds to go to the Supreme Court, to go up to the Supreme Court?
Karen, whether or not they have grounds will be determined by the Supreme Court because of the Supreme Court's expanded jurisdiction. Any decision where the Supreme Court will view as abuse of discretion under the expanded jurisdiction of the Supreme Court, they will look at it and justify it on that basis. In effect, the Supreme Court has become the ombudsman of the entire bureaucracy because of that broad expanded jurisdiction. And maybe the Supreme Court should consider that there should be certain instances when they should refrain from exercising such jurisdiction because it interferes with the power of the other branches who are co-equal, and especially that the impeachment court is the sole has the sole power to try and decide. If you look at this, the plain meaning, sole power, what does that mean? Mr. Supreme Court, you cannot interfere. Mr. President, you cannot interfere. That is the ordinary meaning of sole power. But of course, as you said, the Supreme Court can always invoke their
power to
their expanded jurisdiction to interfere over all decisions of this entire government.
Yeah, if there's grave abuse of discretion.
And who determines that?
The Supreme Court.
The Supreme Court. Right?
Thank you so much again,
Yes.
former Senate President and
Thank you
former
very much.
Senator Judge Frank Drilon. The House prosecution team is bent on exposing the bank and tax records of Vice President Sara Duterte, while her defense team is determined to prevent this. We will find out what happens next when the trial of Vice President Sara resumes next week. Be informed, be insightful of the news. I'm Attorney Karen Jimeno. Always stay at the forefront.